Good morning and welcome to an oral argument session of the Fifth District Court of Appeal. I am Jay Cohen, the better looking version of John Harris. Judge Harris is a little under the weather, but I want to assure you that I have read all the briefs and reviewed the record in this case. Joining me for this session of the court, we've got Mary Alice Nardella, relatively recent member of our court. And then we've got the honor of having Judge Melissa Soto from Seminole County joining us as an associate judge this morning. As I indicated, we are recording this on YouTube, so Mr. Rigby, try to behave yourself this time, if you can. Saying you're gonna have to do that by unmuting, but we are getting good at reading lips. But I think you said something that I can't repeat. I'm not sure. The case this morning is Diana Navarro Perez, now known as Diana Navarro Botero versus Orlando Perez, 20-1448. Now, each of you will be allotted up to 20 minutes for your argument. Mr. Rigby, as you know, we just had oral arguments not too long ago with you. My default is a 5-minute time on rebuttal, but that is negotiable, and we're willing to accommodate any time for rebuttal that you wish. Now there is a cross appeal on this, and so Mr. Geismar, you'll have an opportunity to have a rebuttal on Mr. Rigby's cross appeal. So again, you just let me know how much time you would like, sir, and I'll be more than happy to accommodate you. So that said, Mr. Rigby, you may proceed, sir.
May it please the court, I'm Barry Rigby on behalf of the former wife, Diana Navarro Botero. As the court is well aware, this is the second appeal after a second final judgment was entered in this case after proceedings that were undertaken pursuant to this court's mandate. We appealed for two fairly narrow issues. I shouldn't say simple because I'm not sure that anything is really simple in the family law cases. But our contention is that 23-year marriage, wife with a history of mental health issues, the amount of alimony that was awarded to the wife the second time around is simply too low and rises to the level of an abuse of discretion. The court awarded her 1/3 of the net income. And if you read the opinion from the first case, which I'm sure you did, part of the problem was the net income finding wasn't in there. But Judge Davis Wilson did that, but she gave the former wife 1/3, and we contend that that was excessively low based on the length of the marriage, lack of work history, mental health issues. The statute says that alimony shall not exceed 50%.
Well, Mr. Rigby, let me start out with the fact that you have no transcript. When this case went back on remand, there were a number of evidentiary hearings that occurred, and we don't have a transcript on any of those. And so it's not, doesn't seem good enough to me to say, well, you had the transcript of the first trial when there was subsequent evidence that was presented, and we don't know what it was.
I understand, Your Honor. I don't think that either Mr. Geismar or I thought that we would be here today after the length of the litigation, but of course, here we are. I believe that based on the final judgment itself, on the face of it, the financial affidavits that are part of the record, the court can make the finding that that is too low. I understand that there's a law that says without a transcript, the court is constrained to change what the trial court ruled. But our contention simply is the salient facts here as to the income are sufficiently clear that there's enough there that the court can act. If you agree that that's too low, the findings as to her mental health and I believe the work history are detailed pretty well in the final judgment. So that is our one issue. I don't need to say a whole lot more about it. The other one is the mandate came down in March of 2018. And then in May of 2018, Judge Wilson entered an order terminating alimony. So our contention is that the court should have at least addressed whether any alimony is owed to the wife from that period to the time of the second judgment.
Mr. Rigby, do you believe that the retroactive alimony issue was properly preserved?
I do believe that it was, but I don't believe that there's clear error there, because as the original final judgment says, the wife's needs are partially offset by residing in a home that she was ultimately not awarded. And so this is not a clear-cut issue here. It would require additional proceedings to determine if there's any retroactive alimony owed. And I cited to the Cura case, which I interpret as giving a pretty strong directive to the courts to address those periods of time before the judgments are entered.
I didn't understand what it wasn't clear error. What are you saying?
I do think it was error to not say why the period started with the second judgment. I'm not sure that it's wrong. She may have had bases, but those bases were not sufficiently stated. And I understand that there's some law that says there should have been a motion for rehearing as to that issue. Again, we didn't think we were going to be appealing, but here we are.
Well, if there's some basis for it, why would we, absent a motion for rehearing that might have set out why the judge was wrong, why would we reverse?
Just because there were not sufficient details in the final judgment speaking to that issue. Simply no retroactive alimony.
That's why you do motions for rehearing, if there aren't adequate findings.
I understand. As I said, I don't think any of us anticipated that we were going to continue to fight this case, but here we are.
Do you think there's a particular defect on the final judgment?
Only that the part of the judgment that simply says no retroactive alimony needs to have a finding of fact. It could have been in light of the assets that she got. It could have been in light of her usage of the marital home for an extended period. It could have been in light of the uncertainty of her needs while she was staying with family back in Colombia. I can see, as Judge Cohen queried, there could be a multitude of reasons why it should not have happened, but my client wanted to raise that issue because she was hoping to get an explanation.
All right, anything else, Mr. Rigby?
No, sir. I hope it's okay that my initial part of this is less than 5 minutes, less than 10 minutes.
We never penalize brevity, Mr. Rigby.
Thank you, sir.
All right, Mr. Geismer.
Yes, good morning, Your Honors. Cliff Geismer representing Orlando Perez. And this is a 2012 case. The parties have been involved in litigation for.
No, we know that. We're well aware of all of that. But my question to you is, just on its face, it strikes me as odd that an award of alimony would be made. And when I thought that the earlier alimony award was stayed during the pendency of the appeal, as to why the trial judge wouldn't go back and award retroactive alimony. Let's assume, for the sake of discussion, that Mr. Rigby filed a motion for rehearing and said, well, listen, you didn't hit this, and the judge denied it. Don't you think it would be an abuse of discretion not to have gone back and have awarded retroactive alimony?
Given that hypothetical, it is possible, but that's not the situation we're presented with here, Your Honor.
That's why I called it a hypothetical.
Yes, Your Honor.
Well, why, go ahead and tell me, why, because you understand there is some case law out there that says, even if, there hasn't been a motion for rehearing, and I can tell you that we had the same discussion with Mr. Rigby, who was on the, a couple of weeks ago on a case. Even if there isn't a motion for rehearing, that within the court has discretion to address an issue such as this. Are you aware of that case law?
I'm aware of that matter, Your Honor. I think in this case, the judge's decision to reduce the alimony, while Mr. Perez is arguing that even the reduced alimony leaves him in an impoverished state.
I understand that. I'm talking more about the failure to award retroactive alimony, which had been stayed pending the appeal.
Right.
So she gets zip alimony during that period of time, and then the judge on remand awards permanent periodic alimony, but doesn't go back and give her the 2 years where it had been stayed.
Right. What I was going to say, Your Honor, with all due respect, is that the judge's reduction in the amount of alimony is consistent with the fact that she didn't award retroactive alimony. She is the same judge who stayed the alimony, so she was aware of she was very conscious of the fact and very clear that she was following the district court's mandate. She was very focused on giving the district court following to a T. She was very focused on that. The fact that this is the same judge that ruled a stay on the alimony based on her understanding of what the situation was, and then who heard this case for a second time on remand, having heard all the facts and being familiar with the circumstances, she made detailed findings which are not even necessarily, in Mr. Perez's opinion, borne out by the evidence that was presented.
But under that analysis, she wouldn't have awarded any alimony, and she did. She awarded permanent periodic alimony of $1,200 a month, and it was reduced from what had been previously ordered. But once you do that, why aren't you going back in giving that 2-year period where the alimony award was stayed?
She specifically stated in court that there was no that there was going to be no retroactive or arrearage owed.
Why?
This should have been.
Why isn't that error?
Because she considered the income of the parties. She considered the testimony. She gave detailed findings regarding the circumstances.
But all of those detailed findings led her to make an award of alimony. And it's one thing if she had said, listen, I've considered the financial circumstances of the parties, and I find that either she has no need for alimony or he doesn't have the ability to pay, and so I'm not going to award any alimony. If we were there and she had awarded no alimony and there was no abuse of discretion, then we wouldn't be discussing this issue. But the fact that she awards alimony, I'm still struggling why that is an error, not to have gone back and awarded it retroactively for that 2 years.
Well, first of all, it wasn't requested at trial. And second of all, based on her analysis of the financial situation, she awarded alimony going forward at a reduced rate based on the circumstances as she considered them. I don't think that it is an error. I think if it was going to be brought up, this is not the right place to do it for the first time, Your Honor.
Well,
I don't think that it's a reversible error.
She requested alimony. I doubt she went into trial and said to the judge, Judge, I want you to award alimony on a going forward basis, but please don't give me retroactive alimony.
She never asked for findings on that issue. And in one section of Mr. Rigby's paperwork,
but she asked for that relief, though. I understand that he didn't file a motion for rehearing, but that relief was certainly requested.
The request for alimony was requested, yes, Your Honor. in one section of Mr. Rigby's papers, he says that it's not, a rehearing wouldn't be required. He characterizes it as an issue of fact in one section, and then has it both ways and says it's not an issue of fact in another section. It should have been brought up with the lower court. The judge's decision on remand in its totality is very clear is very clear as to what she thought the equities of the financial situations were. So I don't think that it is an abuse of discretion for her to have clearly stated after her findings of fact that there is no arrearage and no retroactive alimony awarded. And yet I understand that there may be disagreement on that, but I don't think it was an abuse based on the verbiage in her judgment, which is relatively, which she explores the situation in pretty great detail because she knew that she was under the eyes of the district court, and she knew that that was mandated by the court. So I don't.
What findings? What did she detail that would justify not making an award of retroactive alimony?
She detailed the husband's work history. She detailed his current income based on the record, and the lifestyle of the parties was referenced in the judgment, as well as the wife's financial and mental condition, which was never really established at trial except for self-serving statements by the former wife and family members. There was very little, there was almost no documentation regarding mental illness or for that matter, the money that was in the Colombian bank accounts was never, the judge didn't have the bank accounts to reference. She wasn't able to consider the bank records from the Colombian bank account, which was requested probably 8 9
But the trial court made a finding that she had done nothing improper and didn't find her in contempt, didn't consider that. So I don't know, that you can do any differently on appeal than what the trial judge made findings on. That wasn't cross appeal.
Understood.
All right. So would you like to address your cross appeal?
The cross appeal is based on the fact that Judge Wilson understood that Mr. Perez, Orlando Perez, is put in a position where he's living paycheck to paycheck. He's living with family members. He doesn't have his own place to live. He can't even afford what has been ordered by the court. And I think Judge Wilson heard that loud and clear when she reduced the periodic alimony that was to be paid. The fact is, though, that he can't even afford to pay what has been ordered by the court, the lower court. And it does.
Let me ask you this. The same question that I asked Mr. Rigby, which is, she made these findings, awarded $1,200 in permanent periodic alimony. This is a long-term marriage. There were evidentiary hearings held subsequent to the earlier opinion, and we have no court reporter. So why, it seems what's good for the goose is good for the gander. How can you establish an abuse of discretion when we have no transcript to know what the judge considered?
I would agree with the court. I don't think that this case should be remanded back for a second time. I don't think there's sufficient evidence on the part of the appellant.
Well, why did you cross appeal then?
Based on the testimony that was given, despite the fact that there's no transcript that's been produced on appeal.
Okay.
The judge.
Good luck with that.
I understand.
Okay.
Despite the fact that there's no transcript on appeal, the judge's ruling reflects, and her findings reflect the fact that she understood the nature of the financial situations to a large extent, based on the detailed findings that she did give. And Mr. Rigby, in his papers, does concede that he doesn't have any issue with much of what with with the detailed findings of the judge. It's just this one section. And and again, I would say based on the complete, looking at her judgment as a complete document, it is detailed in such a way and reaches the conclusion that alimony should be considerably less than it was the first time around. I think going back for a third time, perhaps with another judge, is going to be very harmful to all parties involved, both financially and otherwise, Your Honors. But the important thing is that I don't think there's been an abuse of discretion, and I don't think it's reversible error.
Okay. All right. Thank you. Mr. Rigby?
Yes, sir. The only thing that I would point out in rebuttal that is on page 1280 of the record, the former wife's written final argument. And that's the middle of the document, but within that document on that page, we laid out the math and the reasoning and what we were seeking in retroactive alimony. So it was before the court. The evidence, one of the pieces of evidence was the clerk's printout that came into evidence was attached to that motion. So certainly it was brought up before the court. Other than that, I have nothing else to add.
All right. All right, Judge Nardella, Judge Soto, any further questions?
Thank you.
All right. Well, thank you both for your argument, and we'll be in recess.
Thank you. Judge.
Thank you. Thank you. All have